Like I said, this is going to be our longest session of the program, but for very good reason. We will be talking all about U.S. policy and law when it comes to data privacy. As you may anticipate, there is a lot to cover, which is why we have these 4 excellent panelists. And I didn't even tell them, and they're already sitting in the order in which they're going to speak. So I'm going to start over there on your far left with Coben Zweifel-Keegan. He is the managing director of the International Association of Privacy Professionals. He engages with kind of all the different players, businesses, civil societies, politicians, regulators, about tech privacy and best practices. He is a graduate of University of Colorado. I know we had some people talking about Colorado last night. And he got interested in data privacy because his unique name makes him very trackable and searchable. And so I actually have some questions about that with a last name like Godlasky. Then I would like to introduce Gavin Logan. Gavin is joining us from Meta. He is the privacy and public policy manager, specifically for Messenger. And prior to that, he worked for the FCC. And before that, he worked for the National Urban League, where he was director of tech and telecom policy. So he's got a long background that he can kind of delve into today. He's also an alum of Northeastern and Brown. And then next, we have Ebbie Yazdani. Ebbie is the federal policy director at TechNet, which is a nonpartisan network of tech executives based here in DC. So that ranges, from A to Z, Apple to Zoom. And so he will be able to talk about all of that. Prior to that, he worked for Republican Congresswoman Debbie Lesko of Arizona, who is on the Energy and Commerce Committee, which handles all of this stuff. So he's got that background that you can ask questions about as well. And then last but not least, we have Rebecca Kern, who is the tech policy reporter for Politico. Previously, she worked for Bloomberg Government, where she helped launch the Tech and Cyber Briefing newsletter. She will be able to talk about ADPPA, the politics side of things, covering Congress. And she has her journalism degree, like me, from AU. So please, let's welcome these 4 panelists. Thank you.
Well, thanks, everybody. This is a great group of people. I'm so excited and I was so eager to be able to help in this to do this kind of worthy endeavor of helping journalists approach this complex and sometimes very confusing subject. So I'm really eager to be speaking with all of you today and with my co-panelists. I'm going to do a bit of an overview to try to give us some foundation. It's very hard to cover all of U.S. Law and policy and privacy in 10 minutes, but I'm going to give it the college try this morning. I think one of the main things I want to focus on is just the fact that data privacy as a practice, both in terms of law and just the operations of doing the work of privacy within organizations, has developed into something that's very principles based. A lot of that in the US is because we don't have a federal law that's specifically around all consumer data, an omnibus comprehensive, we use different words, omnibus comprehensive consumer privacy law. The history of not having that is part of why we have developed this instead kind of principles and best practices based approach to how privacy is done. I can kind of give a brief history of that. Usually people point back to the 1970s when there was a government report that first laid out what were called the Fair Information Practice Principles. Those are still kind of the guiding core sets of principles that are used today with various names and slight tweaks as we've moved forward. There are things like collection limitation, purpose specifications, kind of making sure that consumers have, or people whose data you're collecting have, are empowered, have autonomy, transparency, accountability. Security has always been one part of privacy as well. So those, what are called FIPS, became incorporated and spread in a couple of different ways. They were part of the Privacy Act, 1974, which governs how the U.S. government approaches the collection and use of people's data. That's still in effect, and a very robust law that covers agencies. So whenever they are creating a new system or database, they have to go through all these steps and make sure that it's in keeping with the Privacy Act. International organizations started to also incorporate those FIPS. So the OECD, the Organization for Economic Cooperation and Development, created, they codified a set of FIPS. And that ended up serving as the basis for some of the spread of other privacy laws, like I think you'll hear about later in other countries, like the GDPR in the EU. They kind of run the foundation of privacy throughout the world, with some modernization happening that I'll kind of talk about now. That never quite happened here, even though the EU had first the directive in the 90s that later became the General Data Protection Regulation. The US didn't follow suit in terms of protecting, providing a law that codified those kinds of principles for consumers. What the US did do, however, is create sectoral protections. So you just heard from Mr. Nara about I actually call him Uncle Kirk, but I'll call him Mr. Nara now, about HIPAA, which governs healthcare privacy. I'm sure he did a good job of helping to explain the very complex realities of HIPAA, which show that it doesn't actually cover what people often think that it does when you're thinking about healthcare. There's also specific sectoral laws about financial services, about communications, which he has a background in, about kids. CAPA, the Children's Online Privacy Protection Act, is a robust set of protections for children's data. And basically, that has been the main, at the federal level, those have been the main guiding factors for thinking of privacy as a compliance issue in the past 50, 60 years. There has also been the spread of, especially recently, there's been a spread of state privacy laws that do attempt to cover consumers generally. In the US, we think about privacy a little bit differently than in the EU, in that when I'm using the term consumer, that term would not be used in the EU. That's partially and primarily because of the part that I haven't mentioned yet in the US that does cover kind of the rest of data privacy, which is the Federal Trade Commission. The FTC has authority over competition and consumer protection issues. Consumer protection is the branch of their authority that they used in the past 30 years to try to help companies make sure that they understand what the best practices should be and what are clearly bad things to do when it comes to both data security and data privacy. The way that works is the FTC has the authority to combat unfair and deceptive acts and practices for consumers, and that squarely puts it into this commercial sphere. It's for consumers. And so when we're thinking about privacy in the US, a lot of that ends up guiding what we're thinking about for these types of laws, like the proposed ADPPA, is that it would cover consumers. The FTC does not have authority to enforce against nonprofits, and there's other carve-outs as well. ADPPA actually proposes that it would give them specific authority for privacy over nonprofits, but in general, we think about this in the commercial sphere. because the main part of that authority is about deception, what has evolved from the FTC is a type of enforcement that's based a lot on the promises that companies make. There's a best practice and a standard that we always have privacy policies as organizations. Now, in those policies, we make promises about how we're going to collect and use and share people's information. Those become enforceable by the FTC. I can talk a little bit if we have questions more about the FTC. I love the FTC, and I'm happy to talk more about their authority and also what they're doing right now, which is they're involved in a rulemaking. They do have limited rulemaking authority to create rules and establish kind of black line protections around what constitutes unfair or deceptive practice, kind of in advance rather than on one-by-one enforcement action. But in general, what you see from the FTC are these one-off enforcement actions against specific companies, telling them what they did wrong and putting them under a consent decree and a negotiated settlement that makes sure that they're going to follow best practices moving forward. So state laws are developing now. I think we've seen basically 5 states have passed what constitute kind of omnibus or comprehensive consumer privacy laws: California, Colorado, Connecticut, Nevada, and Virginia. Some of those laws are more robust than others, but California in particular, and also Colorado, have been very active and still working to finish their regulatory kind of finish baking what exactly constitutes their law. That spread of state laws covering business practices has led to more support throughout the community for some sort of federal standard. Companies will point to this idea of a patchwork of different state laws, and they'll say that it's difficult to comply with that. We don't usually kind of silo our operations in different states, and so either you have to kind of decide on what the strongest law is and apply that, or build your systems in ways that can be adapted to different consumers in different states. That, in theory, has led to kind of a consensus about the need for a federal privacy law. But the devil is in the details in terms of what different types of organizations are supporting. So there's still a lot of disagreement. I think Rebecca will talk a little bit more about this among advocates and companies when it comes to what a federal standard should include. I think that's more or less some foundations. I guess one other thing to point out is I talked about how we've focused enforcement on what's in people's privacy policies. There's always been a lot of focus in the US and generally on what's thought of as notice and choice. The idea that you're giving people notice, you're making sure to empower them to make their own choices about their data. And in the last decade, I'd say there's been a lot of problematizing of that idea, a lot of questioning of whether really protecting consumers means always just giving them the choice to manage their data individually, or whether maybe that creates so many choices and so much overwhelming pressure on the consumer to constantly manage their data in many different factors that it becomes untenable. So some of the more recent state laws and also some of the federal proposals are adapting away from that notice and choice regime and focusing on more actually on some of the other FIPS and other foundational principles like data limitations and purpose limitations, specifying limiting what it is that you're going to collect in the first instance and how you can use it, who you might be sharing it with. So that's kind of, I think, a big theme to try to understand the evolution of how privacy practices have changed in recent years. I will leave it at that so that we have more time for everyone else to talk.
Well, good morning. Hopefully you guys have had a nice session so far. And I'm happy, I'm excited to be speaking with you all. Again, my name is Gavin Logan, and I am the Privacy and Public Policy Manager for Meta, and I cover specifically the Messenger product. And so just to tell you what that actually means in real world terms, I know our titles are often not very clear. I do two things. One, I get to talk with folks like these and people in the policy world to understand where policy is going as it relates to privacy. And then the more important part of that is I come back internally and I work directly with the development team, product development team, and I advise them on what they should be doing. I tell folks, the lawyers tell you what you can do. I'm going to tell you what you should do. Right? Just because you can't do it, maybe you shouldn't do it. Right? So that's where I spend a lot of my conversations during the day. And without getting to it, one of the things I think is important that I wanted to bring to you all is a lot of discussion in policy, particularly privacy, and even more so data, right? It seems very obtuse and abstract. And we get into these esoteric conversations about what will happen if this system or that. And at the end of the day, what we're really talking about is people. Now we're talking about people and how they interact with it, how it interacts with them. What impact does it or does it not have on their day-to-day lives? And so one of the things that frustrates me the most is when that part is lost. As we talk about the politics of it all and FTC consent decree, which is exactly the reason my job exists, right? So let's not downplay that either. But ultimately, I spend the bulk of my time trying to understand what do you expect when you pick this thing up? What are your expectations? And we go from there. Are we being clear? We have a list of 8 expectations of privacy, and purpose use limitation was one of them. But also, one of the big ones for us is transparency and control. Are we letting you know what we're doing or what space you're in and how you can control that space as best possible? Right? But ultimately, it's still centered around what our users expect. And one of the things that we've learned over the years as we really tried to dig into this space is that people don't actually talk about or even think about privacy the way we might talk about it, right? It's almost kind of like you don't really think about the air you breathe, you just breathe it. And then something happens and it makes you aware, oh, there's air around here. Do I like this air? Same thing with privacy, right? Nobody thinks, okay, what are my privacy until my phone's act weird. I get that weird text message. Why am I getting these notifications? Right? Something happens to make you think about it. But what most people expect is that as part of this general ecosystem, they have a responsibility. We, Meta, has a responsibility, and our governments have a responsibility to keep everyone safe, right? And so with that being the case, what that means is different for everyone. And so one of the things I talk about a lot and try to stress with folks is that this is not a binary conversation. It is not a static conversation, right? Your privacy expectations change as your environment changes. And so we should be mindful of that, both as we build products, but as we try to figure out what policies we should be developing, and ultimately enforcing and codifying through laws, right? And make sure that we allow for that very human evolution of experience, of understanding. And with that, the only other thing that I'll mention is one of the interesting ironies of my world is that prior, as you mentioned, I worked for the National Urban League, where I spent a lot of time talking on both sides of the issue, both with public interest groups as well as government officials and corporate companies about why a civil rights organization belongs at the table, at these tables. 6 years ago almost, it was strictly a consumer conversation. And so we come so far from that to understanding it much more as almost part of the human condition, right? And so I think it's really and really, really important not to lose that reality. That this is not just ones and zeros and a lot of things. These are mom, dads, grandparents that can be really impacted in great ways or not so great ways based on the decisions that we make, right? So I'll leave it at that.
Thank you, everyone, for the opportunity to be with you today. As Ann mentioned at the top of our panel, my name is Ebbie Yazdani. I'm the Federal Policy Director at TechNet, the voice of the innovation economy. We are a national network of technology executives with over 100 member companies all across the tech ecosystem. Social media companies, platforms, gig companies. For all of our members, data privacy is the single most important issue. We have a list of federal policy principles that are publicly available as a trade association that folks can view. And we lay out our principles when it comes to data privacy. And so as one of the most important points of that is we support federal privacy legislation. We want there to be legislation that protects consumers no matter where they live, and also provides businesses with certainty about their responsibilities so that they can continue to innovate and lead to the next wave of new technologies that empower consumers. So how do we get to this point? I think, as you all know, and as my fellow panelists have seen, this year has been a watershed moment for privacy. Prior to joining TechNet, I worked on the Hill for 7 years for several members of Congress who would hear about privacy and the need for a federal privacy law, and it never seemed to get to a place where a bill was marked up, that there would be something that gained enough traction, because there seemed to be a divide, and I think Rebecca will touch on this, between Republicans and Democrats on how that actually looked in practice. But this year has definitely been something that has been a watershed moment for the privacy debate. I think one thing that has led to that point is, and as Coben mentioned, states are taking the lead on this. There are 5 states that have already enacted comprehensive privacy legislation to protect residents of their states. In this year alone, 31 states have considered privacy legislation. And I think many of them have effective dates in 2023. And so the timing is ideal to try to do something at the federal level. We do want to say that thanks to the leadership of House Energy and Commerce Chairman Frank Pallone, Ranking Member McMorris Rogers, and Senate Commerce Ranking Member Roger Wicker, we have moved farther along in the privacy discussion than we ever have. The ADPPA is evidence of tremendous progress in getting to a place where Republicans and Democrats can agree on privacy standards. It's not perfect. I think with any legislation, there's always, I think, room for improvement. But hopefully that momentum can continue into the upcoming Congress, because I think, as you all know from seeing how Washington operates, for any type of legislation like this to get across the finish line, it needs to be bipartisan. There's going to have to be some give and take on how those provisions are crafted. The other thing that provides a huge tailwind for federal privacy legislation is that the vast majority of Americans support it. Last year, Morning Consult had a poll where 86% of Democrats and 81% of Republicans rated privacy as an important priority for Congress to address. In a hyper-polarized environment that we've become accustomed to, it's very hard to find those issues where 4 out of 5 Americans support a particular issue and want to get it across the finish line. That provides a huge tailwind, I think, for Congress to continue their work with. There's a shortened calendar between now and the end of this Congress, but we're hopeful that they can continue to move forward in the 118th Congress. I do want to point out a couple things that I think could be done to improve the legislation. So while it provides a lot of consumer benefits, a lot of clear rules for businesses on how to handle consumer data, how to protect consumer data, there are things that can definitely be improved. One of which is on the private right of action and on preemption. There's been talk about, how should a federal privacy bill impact various state laws. But if we look back at how just the nature of how Congress and states have overlapping regulation, Congress has jurisdiction over interstate commerce. And if there's anything that's as ideal a topic for interstate commerce, it's data, it's the digital economy. And Congress has the means to be able to adequately preempt various state laws that are maybe conflicting in nature. If we allow a patchwork of state laws to continue building, and or if Congress is unable to fully preempt state laws, there's going to be a tremendous cost to America's economy and technology leadership. There was a study released earlier this year by the Information Technology and Innovation Foundation entitled The Looming Cost of a Patchwork of State Laws. And their estimate, if 50 states enacted a variety of comprehensive state privacy laws, well-intentioned laws to protect their constituents, it would lead to a cost of $1 trillion to the economy over 10 years, and $200 billion of that would be borne by small businesses. That's resources that they cannot invest in hiring workers, investing in new technologies. And so it's very important that we are able to have a uniform standard in order to get it right. Some state laws that have been on the books provide a cautionary tale of what to avoid. As many of you all know, Illinois has a biometric law on the books that was first enacted in 2008, I think before many of these technologies that we now take for granted took off. It has turned into a cottage industry for class action firms. Without there being a requirement to show that there was any harm, businesses are going to be on the hook for violations of that law, to the point where I think even Illinois lawmakers are considering trying to refine the scope of that bill. That is one flaw with respect to the ADPPA, is that in their preemption section, they actually expressly include an exception for BIPA in Illinois. So the hope going forward is that Congress is able to get a privacy bill, comprehensive privacy bill across the finish line sooner than later, and we stand ready to serve as a resource to policymakers in that effort.
This is great lead up to what I can discuss, which is ADPPA. It's the American Data Privacy Protection Act. And as he was saying, that this was introduced this year with what they're calling like the three corners of the top negotiators on the central committees in Congress. So House Energy and Commerce, you have the chair, Frank Pallone, a Democrat, and then the ranking member, Kathy McMorris Rogers. They have not agreed on the basic tenets of these two issues called the private right of action, which is also called a PRA, and that's just a kind of a legal term for saying allowing individuals to sue if your privacy is violated. That is something Democrats have wanted for a long time and doesn't exist really in any of these state laws besides California in a minor instance of if you have a data breach. But that is a big push for Democrats, and that's not something they've been willing to give up on. And whereas where Republicans have not been willing to give up on the issue of preempting state laws, they want one federal standard, and as you know, as a lot of companies are saying, it's a lot less costly to have one law to comply to versus up to 50 states, which we could head that way. We have 50 data breach notification laws currently on the books, and we have no federal law. So it isn't really hypothetical. It could head that way, and we see a lot of states moving to have privacy laws because, as a lot of the panelists are saying, consumers want this. They want protections, and we're one of the few developed countries that doesn't have a federal privacy law. GDPR in the EU has existed for a long time, and a lot of U.S. companies, it's kind of in effect here because they already comply in Europe, and so it's somewhat of a standard here. California's law is somewhat of a national standard here, in lieu of a federal one. But that's a line Republicans have really not wanted to give up on. So where we saw some compromise, and Politica, we wrote about this earlier this year, was that Republicans agreed they would allow for a delayed implementation of a private right of action, 2 years, to allow companies to get up to speed, and it is costly to have a legal department, and this is why a lot of companies, particularly startups, have not wanted to have the ability to be sued on these issues because it could be very costly. So it allows a delayed implementation of that, and then there are a few state laws that will be in effect in that the federal law wouldn't exist in concurrence with like the Illinois biometric law, California's law. So they do call out a few laws. Not in the end, if you follow Congress, neither side is really getting exactly what they want, but that's kind of how legislation is made. It moved out of committee 53-2 in House Energy Commerce, very impressively large bipartisan vote. We don't have a companion in the Senate, and this is the biggest challenge. The chairman of that committee, Chairwoman Maria Cantwell, on Senate Commerce Committee, has not supported it, and she claims it doesn't go far enough, and has not really offered a countermeasure, and as a result, it will probably not move. I mean, her ranking member, Roger Wicker, is supportive, but he doesn't control the agenda of that committee, and so. And I think a lot of privacy advocates are disappointed that she's not on board. And even Majority Leader Chuck Schumer has said we're not going to take up a House bill that doesn't have all four corners, all of the committee chairs in agreement. There's really no point. So I mean, unless the Hail Mary moment happens and Cantwell gets on board, I don't predict ADPPA moving this Congress. They have a few weeks left and have to pass a budget or to keep our government open. And the NDAA, a lot of pressing issues. And unfortunately, as much as consumers and companies want privacy, this is not necessarily the priority for Congress at the end of this year. Where we are looking next Congress is a House flipped and controlled by Republicans, and it sounds like Kathy McMorris Rodgers wants to, reintroduce this bill. She will have the gavel. We'll see if she will be as willing to work with Democrats in when she has the chair. Another holdup this year has been Nancy Pelosi, the House Speaker, put out comments in September saying she's concerned about how this is going to affect her state's bill, which is a law which has been in effect for several years, the California privacy law, and doesn't want it to weaken it. Although a lot of outside groups, and I think all of you could probably say this law would be stronger likely than California's because you would have the FTC's ability to enforce it. Right now you just have the California Attorney General, and it really only protects Californians. So. But without her support, there's likely no interest in her bringing it to a House floor vote. There's likely backdoor negotiations ongoing. I don't know if anyone else on the panel has a different assessment. I don't think this Congress is going to move. But as everyone was saying, and as someone who's covered it very closely for the past several years, this is the furthest Congress has ever gotten. I think a lot of people were surprised. There was bipartisan agreement, at least among 3 of these lawmakers, and it did show both sides were willing to give up some of those biggest issues, and it was a pretty big win for a lot of civil rights groups because there's some provision. When these big comprehensive laws come together, a lot of lawmakers use it to bring up some of their smaller bills and combine it. So there was this Algorithmic Justice Act, a Democratic bill. It would prevent these covered entities from discriminating based on personal characteristics like race or sex. And so, and it would also mandate the covered entities do an algorithmic impact assessment. These are pretty big deal issues that haven't really come to the forefront, and unfortunately is kind of a small bill that wouldn't have moved on its own. So that is the advantage of wrapping up a big comprehensive bill and bringing forth some of the other, I mean, arguably very important issues that algorithmic, injustice and just tracking how algorithms work is not something I think Congress has a great handle on. It is something Facebook whistleblower Frances Haugen talked about, obviously before Congress, over a year ago now. And so that is wrapped up in this bill, and we'll see if we have a Republican control next year if that stays in it. That was a big win, and it was hard fought for a lot of these groups. And there's a lot of other provisions I could talk about in the bill itself. But that's when we're tracking. Another one that is moving somewhat in parallel. The only privacy really that bill in the Senate is the update to the Children's Online Privacy Act, which is over 25, I think, years old and pre all social media. And it really only protects children's privacy up to age 13. And we know all these kids are obviously on all these apps and under age 13 even. And so it would up the age restrictions that these companies have to comply with privacy and limitations on data collection up to under age 16, which still, doesn't go as far as some of these lawmakers want, which was under 18, but it's further than it is currently. That passed the Senate Commerce Committee. But like I said, the House doesn't really want to take that up if they're not taking up their comprehensive ADPPA. So we're at a standstill here. ADPPA does have expanded children's privacy protections. So they're saying, well, why don't you take up our bill? It already includes that. So you see a lot of jurisdictional battles. And unfortunately, I think in the end, consumers and kids will lose out when no bill will pass, I think, this Congress. And industry even wants it too, which is not always the case for legislation these days. So it's an unusual time. It was a fast push, and then it likely is dying, sadly, for people who want it fast. But yeah, that's kind of the quick overview of where things stand in Congress.
Thank you all. I want to open it up to questions now. So if anyone has any, just raise your hands, and then if you're directing it towards a certain person, let them know. Otherwise, it'll be kind of free for all, whoever wants to jump on it.
Hello. I think this can probably go to all of you, but something that I've kind of struggled to understand is without a private right of action, what's the recourse? Like the FTC might be able to pull up something big, like if it's, say, Twitter isn't deleting my data when I ask them to, they would do that, but they're not going to go after the smaller mom and pop shops. And California Protection Agency, I guess, is who would do that in California. Is that right? So without a private right of action, like, what's the point?
Yeah, that's a good question. Do you want to start?
I think we would absolutely support there to be some form of recourse. The ideal approach would be through state attorneys general and the FTC as subject matter experts. State AGs being accountable to their constituents can prioritize the cases that have merit versus cases that are filed that may not have merit but still impose significant costs on a potential defendant. I think there's a sense that if the case doesn't have merit, it's fairly easy for a small business or a startup to just dismiss the case, but it can add up to significant costs, especially if a court interprets a statute as not requiring any harm to a particular individual. If it's just a procedural violation without an opportunity for a business, a startup, small business to have a chance to cure the defect and address it within a reasonable amount of time, it could cost a significant amount of money just to say, look, there's no claim here, versus an AG pursued claim or an FTC pursued claim where there's a little bit more accountability in terms of enforcing consumer rights.
I'll speak a little bit to that in a different context. So prior, I used to be an assistant attorney general for the city of DC. And one of the things that I was in charge of was regulatory enforcement of the cable system in the district. And so generally speaking, when your cable went out or it shouldn't have, you can't just go sue, right? So like there's no, in the truest sense of form, no private right of action there. But it was recourse for everyone. Like I literally was, like I took a call from Larry King one day, and he, like, and so there can be ways to make sure that people are protected and their voices are heard. I think a lot of times we just have to be open and be a little more thoughtful about that process, because also there's on the flip side, one of the questions that I would ask when I was at the National Urban League is it presumes that individuals have the resources to bring their own cases as well, right? So those people who don't necessarily have the resources have to equally be protected. And if you just leave everyone to fend for themselves, that's not also the ecosystem we're trying to create as well, right? So like it's the other side of it that I think people also should be mindful of too.
I think you both created a good overview there in terms of what the alternative to the PRA is, which is really the main focus is enforcement activity. So yes, it would be the FTC. ADPPA provides that both the FTC and state attorneys general are empowered to enforce it, so that it does create that all 50 states would be able to enforce. We currently have the same environment basically for what we have, which is that states also have mini FTC acts that are called UDAP statutes that cover unfair and deceptive acts and practices, and they've often collaborated with the FTC and bring enforcement actions in the past. What would be different in this environment is you would have the clarity of the text of this kind of law instead of the kind of common law of privacy that's developed through the FTC's enforcement over time. No.
No. And that's a big complaint among a lot of people is the FTC is continually underfunded, and there is no privacy, like a large privacy division like in Europe. Each data privacy agency within every country has their own privacy office. So arguably it needs a lot more funding. That has been proposed in budgets, and even in the Biden administration, it has gotten more funding over time. But yeah, this is just like a bill, and then separately it would have to be appropriate. Funds would be appropriated.
Yeah, and it would though create that separate division at the same level. The FTC currently is divided into just a few divisions, and one of those it specifies that it would be the same size of the current divisions. So it's unclear exactly without the funding piece how that would work, but ideally then that would probably hopefully eventually come with additional funding as well.
Yeah, other more progressive lawmakers have pushed for a new privacy agency. That's probably never going to happen. I mean, it's just like no Republican will get behind a new bureaucratic regime. Arguably, FTC has all the authorities. It just needs more funds, and a new office could really do it. I mean, versus starting from scratch.
I have a question for Rebecca or anyone else. What kind of enhanced privacy for children, is being contemplated?
Yeah, that was so. COPPA was it 98 or yeah. So it's old, and that is enforced by the FTC, and it's only 13 and under. So Ed Markey was in the House when that passed. Now he's a senator. He's the one who introduced it's COPPA 2.0. In 2021 with Bill Cassidy, a Republican from Louisiana, and it passed out of the Senate Commerce Committee this year. Not unanimous, but enough bipartisan support, and that would expand privacy protections under 16, so 13 to 15 is my understanding. And it would be better than what we have now. I mean, arguably, kids advocates don't think it's enough, but it would give FTC authority to go after companies that are, collecting children's data and without authority, and you need parental consent. And I mean, it's a tough one to enforce, to be honest, because kids can make up their age, And age gating is very difficult, arguably, for tech companies to really deploy, because in order to confirm someone's age, you collect more data, and then that's filing potentially more, you're collecting, and that causes potentially more privacy concerns. So it's this kind of circle where, and I mean, Europe is trying to do it, and it is a challenge. I think this is where we really have strong bipartisan momentum behind kids' privacy specifically. I think the concern is that if we move kids without comprehensive, we lose the whole chance of getting comprehensive passed. That seems to be a bit of a fight. I don't know what other people think about that, but.
Yeah, I mean, this is a big trend for sure. Obviously, kids are always top of mind for policymakers generally. It's an easy thing to talk about. It's an important demographic to protect. We're seeing a couple of trends in that area. For starters, we should highlight that there's 2 bills in the Senate that cover kids protection, both COPPA 2.0 and then something called the Kids Online Safety Act, COSA. That one is more along the lines of this kind of theme that we're seeing in a lot of places around safety bills that are not, it's not really a privacy bill. It includes privacy components, but it's concerned about a lot of different harms to children and teens, not just their privacy, but also their safety from other people, their mental health, their addictive behavior on apps and websites. That was spearheaded, as you mentioned, in Europe. There's the UK created an enforceable regulatory code called the Age Appropriate Design Code, and that has and Ireland has similar guidance out. But California actually has passed, and now there's a law with the same name, the Age Appropriate Design Code, and it is a design code. It creates rules for people like Gavin looking at teams. They're building products to say, look, these are the things you need to be thinking about to help protect kids and teens. So that's the other big theme, is we've seen this expansion from just under 13s to cover this whole the wide range of youth. But it's a complicated area, as Rebecca mentioned, because there's so many different, a 3-year-old is so different from a 16-year-old. And that's why age appropriate was a really interesting idea, where they're kind of thinking about what are the different, how do you respect children's autonomy at different times in their lives, but also parental autonomy. TAPA, the existing law, is very focused on parental control. These other proposals are, so COSA and the California law now are not as focused just on parents. It's also about the kids themselves.
Another issue with COSA is that bill, which I think the parallel would be in California, the ADPPA, is a lot of privacy groups are coming out openly saying, we're concerned you're going to collect too much data on kids, like I was saying, and surveil kids, because it allows parental control tools. And then there's some concerns, probably very valid, like from GLAAD and other advocacy groups, that parents that are more conservative leaning could be spying on kids exploring their sexuality or different issues that, or religious issues, or you name it, and that could spur potential harm for kids in the end if their parents are watching their activities on these apps. So it's a very nuanced and complicated thing to regulate, and I think companies largely in any field don't want prescriptive laws that in the end may not solve a solution that you're trying to solve. And but I mean, California moved forward, so, and it's also an awkward thing for a company to be like, we don't support kids' safety. It's not a thing you're gonna actively lobby against. I mean, so it does create interesting bedfellows, and in that a lot of privacy groups and GLAAD and individuals are pushing actually against COSA, the Kids Online Safety Act, because of other downside effects on surveilling kids. So we'll see. There is a push to put that on the omnibus bill, which is the must-pass bill this fall. We'll see.
Yeah, that's the one thing we might see
That
happen,
could
but it's still a glimmer. It's a glimmer in someone's eyes right now.
I don't know if the House will support it.
As someone who kind of grapples with some of these issues, thank you for that plug.
I don't think you would say you wouldn't support it.
It is actually one of the interesting things, that conversation that I have with folks around this issue and others similar, is that there's a perception that it is so easy to do. You know, man, you're huge. Just get it done. Like we've been trying really hard for a long time. You know, it's and so I think it goes to the earlier point that I made of like these are dynamic issues. They're not static and they're not binary, right? And there are, frankly, trade-offs. You know, when in order to do this, you really have to be cognizant of what those are, because yes, we want parents to be able to have a lot of say over what their children are being exposed to, but we do know that the children, the parent may not be the greatest keepers of that space. But like one of the things that we do is we try really hard to avoid unconnected minors from being contacted by adults, right? So a general rule that we as a company just decided is that if someone is 16 years old, and we have different ranges, so we actually do like a 12-year-old fundamentally different than a 16-year-old. It's not just young people, right? But so a 16-year-old who's a minor, we don't think as a rule a random 45-year-old person should be able to contact them unless they already have a connect. There's reason to think. Yeah, and so that is kind of our default. But some of the challenges are like we don't always have control over the creation of that person's account, right? So like a lot of time parents to create accounts for the kids. And so it goes to the question of age verification too, right? Like how do we confirm that this person is John Doe, age appropriate person? And yeah.
Yeah, and all of the big tech companies have highlighted the work that they've done in response to the age appropriate design code. It's all kind of, it's not consistent necessarily, right? They all are like, oh, look at this great thing you've done. And I think that's maybe a thing that advocates often highlight and saying, well, maybe the laws need to be a little bit more prescriptive. But there's a lot of factors that go in. Like people are constantly learning and trying to make that stuff better.
Thanks. First of all, I think it's sort of funny to point to the cable operators as an example of regulation working properly. If anyone was watching the Warriors game in the hotel last night, the DirecTV went out, and I personally think I experienced harms. But more to the point, as coming back to the private right of action, and I don't know that necessarily individuals suing Meta or organizations is the right path, but doesn't requiring FTC and the AGs, which have all kinds of priorities, which are not necessarily always consumer protection, doesn't that create a situation where firms have the ability to sort of make risk-based judgments about what laws they're going to comply with? We have lots of examples of tech companies saying, we're just going to do this and let them come after us and then we'll change. And it sort of sounds like the way that this law is constructed and without private right of action, that would create a similar scenario.
I mean,
go ahead.
I was just going to highlight, I think that gives me the opportunity to highlight one kind of theme that I was listening to from everything that we were saying, which is, although in DC we have a tendency to focus on legislative and regulatory activity, the practice of privacy is something that often goes beyond compliance. Now as we see more and more laws coming into place, it is often more focused on compliance. But this kind of living, breathing thing that has become the privacy profession is something that is principles-based and impacted by kind of, it evolves over time and tries to respond to those risks. I'm mindful that we don't have a civil society voice on here, so I will try to channel that perspective a little bit more in answering the question. I think your point is well taken that it's without a private right of action, individuals are disempowered to bring your own faces when there's egregious things that are done to their privacy. I think part of the issue has been drawing that line. I think this is where it kind of came to in terms of discussions on the Hill, is drawing a line around what constitutes a bad enough thing in data privacy that it should be something that people can sue about. In Europe, people can lodge complaints with their privacy regulator. There are mechanisms for it's just a very different culture when it comes to suing in Europe. And so this would be kind of a new undertaking to empower people in this way. And as we've seen, my other panelist was highlighting the BIPA, the Illinois law. I think advocates would say that it's not necessarily bad that companies have a lot of things to do when it comes to that really sensitive data, is biometric information. But it does, we just have to be careful about how you're constructing those things, because we are a very litigious society, and it can lead to a lot of going around that might not necessarily move things to better best practices. I think that's where I'm always going back to, is I'm really focused on what spreads best practices throughout the ecosystem. And yeah, I guess my main point with the beyond compliance thing too for reporters is that it's helpful. I love that Gavin mentioned that we should focus on, we ask the question of what should we do and not what can we do. I think often reporters will be like, is this legal? And I'm like, probably, but that's not necessarily meaning that we should do it. And I think often privacy people and organizations are trying to ask that, should we do it question.
I completely agree. Also, with the direct TV example, I agree it's an actual harm. In the context of private right of action, typically for a plaintiff's case, and the incentive there is that there's a contingency fee that an individual plaintiff can recover up to a third of damages. What makes privacy unique is that it's a very intangible set of harms, and there's precedent for enforcing those. But in the case of, as Kogan mentioned, BIPA, it devolves into class action cases that try to build up as many procedural violations as possible for companies to be on the hook. There was recently a case with BNSF Railway where they had collected biometric information for security purposes on their site, but had, I forget the specific details, but had improperly complied with BIPA, and it led to a significant amount of damages there because of the way BIPA was structured. I think Congress and House Energy and Commerce specifically, when they crafted ADPPA, while they do have that delayed phase-in for a private right of action in the bill, in the most recent version of the bill, they added an exception for for startups under a certain threshold of revenue. I think that was an acknowledgement that larger companies can stomach those costs, but for a startup or a small business that is engaged in the digital economy, one class action lawsuit is a death knell for innovation. And if we're trying to really grow America's tech leadership, we also want to make sure that companies of all sizes all across the tech ecosystem have a means to continue to grow and minimize those unintended consequences.
Yeah, I mean, and I think just my point was more that I really do believe that a lot of privacy professionals are there's a lot of people and the practices are there. I think the reason that everyone's asking for laws here is because the practices have fallen short, right? Like in many instances and in many organizations, they've fallen short. And so I guess I'm just, I don't know, looking for some resolution between those two, the tension there.
Yeah, I think there's always this, I think tech innovation is at a fast pace, and I think we are seeing harms from technological changes that aren't necessarily anticipated. I think maybe the kids, some of the hearings about kid safety really highlight some of those harms that are just sort of side effects of internet platforms that we wouldn't have been able to consider or predict. In some ways, that speaks to maybe regulation needs to catch up to help make sure that there's standardized practices. I think there are multiple ways that the practices become standard. I think over time, what counts as reasonable security, reasonable privacy practices also shift, and that exists in the current framework where the FTC consistently is revising what it expects companies to be doing. But I guess the other point, though, on the other side of that is that technology continues to change. So we need to make sure that we craft regulation in a way that those harms and also benefits that we don't necessarily foresee aren't going to be kind of brought into this to laws that are maybe poorly written or not thoughtful about how things will develop in the future.
So this question is either for Coburn or Rebecca, but I can open up to anybody. And this is tangential to the legislative question, because with Congress maybe not making any movement on a national legislation, the FTC has made some noises about rulemaking.
Right.
So my question is, A, within its limited authority, what can the FTC do? And B, how likely is the FTC to do it?
Yeah. And Coven probably could speak specifically, but I do know they're starting a privacy rulemaking on surveillance and those issues. The biggest complaint is it's years in the making. It's super transparent. Everyone can comment. There's notice and comment periods. There's multiple versions of that. Then they do a rule, and an administration could change in that time, and the leader of FTC could change, and they could choose to stop doing the rulemaking. I mean, that's how long it could take. I mean, we have Lena Khan as chair. She's very active on tech and privacy issues, as you know, big anti-big tech person. So she's all for this, and it is in their purview, but they have limited rulemaking authority. That is something that lawmakers are pushing to expand FTC's rulemaking authority and give them first fining authority. They don't have that now either, but that's my extent of the knowledge on the practice. But you probably just commented on the notice. And,
No,
oh, you guys did.
I'm blessedly.
Oh, they got delayed?
Yeah.
Yeah.
Well, no,
Yeah.
because so we're policy neutral, so I don't have to.
Oh, you don't
comment on
have
things,
to. Yeah, that's nice.
But which is nice. But
Yeah.
now, of course, I'm realizing I have to read everyone else's comments,
Yeah.
and try to make sense of them, and help everyone understand what they say. So, my work has been shifted now to now. But in any case, the comment deadline did just pass for the very first step for this rulemaking. You might be more familiar if you cover congressional or regulatory activity with APA rulemaking process. That's the more standard process. It takes much less time. It's sort of, notice and comment periods, multiple stages. When Congress gave the FTC the authority to do this specific type of rulemaking, they really limited it down and wanted it to be something that only happened in certain circumstances, and they added a couple of hoops the FTC has to jump through. One of those is what we're seeing right now, the advanced proposed rulemaking, would basically ask, should the FTC do this thing if they were to do it, and why is it that the FTC's existing enforcement activities haven't been enough to fix the things that they would do through this. In order for the FTC to get a rule finalized, they'll need to have that evidence. This big amount of information that they're collecting right now. They'll need to be able to support the idea that there's pervasive practices throughout the industry that are harming consumers, and that consumers cannot readily avoid those harms. So one of the big questions in this first step is like, what are harms? And we just talked about harms a bit. What are the harms that are driven from privacy? This is always a big theme in privacy thinking and court cases and everything else, because it's such an important factor both for the FTC and for private rights of action. But that will help. So they've opened up this big long process that is kind of a funnel. They're starting at a really casting a broad net, and then in theory, most likely they would then narrow that moving forward. But because it's a long process, and they do know that it will take probably across administrations, I think they also have multiple goals in doing this. It's not just to get to a final rule. They also want to establish this record that we just got. Everyone commented, all the people that think we have an amazing group of society and industry folks who think about this all the time, and they all submitted comments, so now we have people have written down their thoughts, right? And that's a really cool record that the FTC has also indicated they hope will inform Congress as well.
We were very pleased. TechNet did submit comments for the ANPR. When it was first announced, I think it was Commissioner Slaughter and Commissioner Bedoya both indicated that if Congress were able to get ADPPA across the finish line, that they would oppose further advancing of an FTC rulemaking. And so I think there's an open question of whether an FTC rulemaking on privacy would sufficiently preempt state laws, or whether it would just add on to the existing patchwork. And so ultimately, the ideal approach would be for Congress to get something.
Taking this back to kids, because I mean, my daughter just turned 13, and when that happens, you get this really horrifying email from Google telling you you have no control over their Google account anymore. And then also an 8-year-old who has TikTok, Instagram, all of that stuff, and no one seems to really notice. But it's, is there any, I've always found COPPA to be kind of toothless because it doesn't really regulate what can be collected. It's more about parental consent, which is important, but I think more shifts the blame than anything. At the same time, is there any move with the new version of COPPA or other laws to maybe reduce or regulate the amount of data that can be collected on kids, how it should be protected, and who it can be shared and sold with? My kids go to New York City public schools. I've gotten 2 data breaches in a month, notifications from my daughter about ed tech providers. And we can talk about the evils of social media, but what about all those third-party companies that our school districts use? They're collecting and potentially selling and sharing our kids' data too.
I mean, yes, it sounds bad. It is bad. That's why Frances Haugen came forth. I mean, arguably Congress hasn't done anything. It's been 14 months since she testified. The most substantive outcome was Kids Online Safety Act, and California went for it and did it themselves. So I was part of a really sobering listening session with parents, with Senator Blumenthal and Senator Blackburn, who are co-sponsored that bill, whose children committed suicide based on challenges on TikTok and Snap and these other apps. And there was not really a dry eye in the room. I mean, it's awful. 2 bipartisan lawmakers of very different mindsets are pushing for this. And for these parents' sake, I really hope something happens. But again, it does shift the blame on parents still, because COSA does, mandate these companies create parental controls, but then ultimately, parents will set the controls. And we haven't talked about it because it's not privacy, but there's Section 230, which will prevent individuals like these parents who are trying to sue these companies after their children committed these acts, and they lose. So in court, because this is a law that protects companies from being sued for third-party content. And there's really no bipartisan agreement on how to change 230. We don't have to talk about it again, but that is something that is likely the reason why it's very hard to put forth, online safety laws, to be honest. I think maybe others disagree.
So I think just to highlight that, yeah, exactly, yes. And then I think the answer to your question about whether there's proposals that address this collection, use, and sharing limitations. Yes, the AADC in California creates requirements around, and I'm trying to think about, I don't know that I specifically remember what those are in terms of sharing restrictions, but it overall puts more emphasis on the company. It applies a best interest of the child standard that is almost like a duty of care for companies to be thinking about the child's interests and privileging them above their own financial interests. And that is a unique thing that to see. I think that's something along those lines is also proposed in COSA, and it also kind of that happens to jive with a lot of academic thinking on ways that privacy law could be modernized and making companies more kind of having a duty of pursuing their interests, or at least not harming their users. But yeah, I think looking into actually the California law really hasn't gotten enough attention, and looking into some of those details would be probably worthwhile, because I think it is enough to address that.
This is a specific sort of focus, but it's open to anyone. And but just a clarification. So Abby, you mentioned the Indiana data privacy law earlier?
Illinois.
Huh? Illinois. So that's what I wanted to maybe get some more context on, because I've heard from many privacy advocates that it is the standard. It should be sort of adopted on a more national scale potentially. It's great. But I wanted to get further thoughts, I guess, in general, in terms of that biometric data law and sort of that the standards around that. I mean, I imagine that's also been incorporated into lots of other proposed legislation. But I just wanted to hear more thoughts on that in particular, because it is, people kind of point to California and it's emerging sort of data privacy laws now, but as I understand it, they've had this law since 2008, right? And it's something of a standard as far as I understand.
I'll say it on BIPA specifically, on the Illinois law. I think we agree that, and our members agree, that there needs to be heightened protection for biometric data. ADPPA at the federal level includes it under the definition of sensitive cover data. I think that the vast majority of Americans would agree that that kind of personal info should be subject to heightened protections. The trade-off with it is if there's an enforcement regime as open-ended as Illinois' BIPA, it discourages companies from innovating and offering services to to residents of that state. I think the other challenge is, and my co-panelists have mentioned the need to have flexible frameworks that keep pace with innovation. Is since 2008, the amount of new technology that has developed is fairly significant. The way that we interact with each other online has changed dramatically. Ordering rideshare services was something that didn't exist at scale as it did in 2008. If you have a law there that it allows for very broad litigation against companies for procedural violations, it does quell innovation versus a framework that can be updated and provide some uniformity to companies, but also provides clarity to consumers.
And I jump in there to show some of the complexities, right? And I'm going to use myself as an example. So I don't know if you can see, I wear hearing aids. And when I was preparing for this panel, I didn't actually know we were going to have microphones. And one of the things I was concerned about was oh God, they're all going to be wearing masks. I'm not going to be able to hear nothing. I rely on reading lips more than listening, weirdly enough, right? So my plan was, my hearing aids are connected to my phone. I can turn my phone into a microphone. Think of all the data that I would have just created, including biometrical data. Should you guys be notified that I did that? What does the company do with the sound of your voices, right? Like this is how quickly complicated it can get. And so to this point, why would they create this thing that helps me literally communicate and get through the world if the potential penalties would literally just make it an effect, like why bother trying? Because I'm probably going to mess it up at some point because this is new stuff, right? So that's a very innocent example, but one that that's very real for a lot of people, a lot of companies, and the thing that we spend a lot of time thinking about. So one of the programs that I worked on, literally anytime we're doing anything new with data that hasn't already been approved. So it doesn't have to be creation of a new product. It could just be saying, hey, we've been collecting how many times people click the like button, right? As an example. We want to use that information, not to just tell us how many times they click the like button, but what they actually liked, right? So just say, that has to go through a review process. And I look at it, our legal team looks at it, about 4 people sit and look at each one of these things, right? And we're very proud of our program. But But it's not something that a lot of other companies are able to do and that are doing, right? And so I think to the point is that you really do have to think further downstream about just rethinking, just understand it's not that black and white, you know? Because like, your voice, depending on the definition of biometric data, which is a whole different debate, could be biometric data. And I literally could have easily just been collected and sent it through the app and they would have it. So, yeah.
Yeah, and I think this gets to something we didn't really cover, which is just the, in the practice of privacy in the U.S., we think of kind of personal information as one bucket, and then sensitive. We generally have kind of the term sensitive data to cover types of personal information that deserve higher standards of protection. Sometimes more focused on opting in versus opting out, things like that. I think I don't know that advocates hold it up as an example of the perfect privacy bill, but it certainly I think is held up as an example of one way you can create those private rights of action and one way that you can protect a specific type of sensitive personal information. A lot of academics are incredibly concerned about the spread of biometric technologies, especially facial recognition, and there's a movement to ban it to get rid of facial recognition completely. But it is really complicated and nuanced because facial recognition, even if you just look at facial recognition, it's not, there's multiple stages involved and multiple different ways that you can create, that you're thinking about that type of technology. It might just be for a security purpose where you have a limited set of, a limited database of certain things that you're checking the person's face against and you believe you have to get it. Or it might be a search engine on the internet that calls websites that we're trying to load and contextualizes people's photos wherever they find it on the internet and allows you to search by face. That kind of thing is very scary. But there might be enough uses that maybe help with accessibility or security. They're very good purposes that some of these technologies are put to. And also to the idea of defining biometric, it's challenging because a photo, I mean, even his example, an audio recording in and of itself isn't a biometric. It's that further processing down the chain where maybe you would be making an inference and saying like, oh, I heard a voice and can create a voice print, match it against a different voice print, but now it's a biometric. But so it does kind of have to do with how it's processed.
I have one kind of basic question that I just don't think I'd ever get to answer on deadline, which is if the industry wants nationwide policy, standard policy, and GDPR provides a type of framework for that, and many businesses already comply with GDPR. I know it's more complicated than this, but why does an industry just support a carbon copy of GDPR? What are the specific parts of GDPR that lead you to not want to support that type of framework for the US?
I can speak generally on behalf of TechNet, and we don't engage in kind of EU policy process, but I will acknowledge that many of our companies are in full compliance with GDPR. It's something that I think is part of the reason we're here is that the EU took a leadership role in getting GDPR across the finish line. There are some unintended consequences with the scope, my understanding of GDPR. One, I believe that, and it came directly out of GDPR, are the pop-up notices that we tend to experience on any type of online platform. That reason that exists, and it's one of the kind of discussion points for any type of federal privacy legislation, is requiring consumers to provide affirmative express consent. And that's good. Like, it should be provided at the outset. We want to be able to empower consumers to make that decision. Every single time they do it, actually it has less efficacy. I go to any website now, and I'm so used to seeing those pop-up notices, I automatically click accept. I do not read it because I have just seen it so often. If you were to apply that kind of same standard to every possible collection, processing, or transferring of data, in the context that Gavin mentioned about the biometric information is audio recording. It gets collected at the outset, and there should be an affirmative express consent. It gets processed, whether internally or by a third-party service provider. Should the consumer get the consent or have to provide affirmative express consent at every possible iteration? I think if you were to require that, it would lead to the same outcome and actually slow down some of the, the consumer technology that's really empowering people. And consumers would treat it the same way as some of those pop-up blockers that we started seeing, the cookies notices.
I will say that we obviously are in compliance with GDPR, but it does. I have a lot of interesting conversations about the notifications, right? And so what I say is, hey, are we telling them we're doing this? Okay, well, how are we telling them? Is that clear enough? Right? Like, so it's not. It really does become a thing. And just for years, when I started getting into a lot of these issues, what you mentioned is a real thing. People will either just walk away or just rapidly click. So the question then becomes, like, is it having its intended effect? And so one of the things that we spend a lot of time on is how do you get that impact? Like, how do you make sure that they not only can understand the information in a very concise and clear way, but they go through it and don't just kind of quit, right? So we don't want people to just click through either, but we also don't want there to be so many clicks that they just quit and don't ever use it. So it is the natural interest.
And I totally get that just becomes furniture and you just gloss over it. But I mean, are there any proposed solution? Like, how else do you go about it without asking somebody first? I mean, maybe there's no solution, but I just don't see.
Yeah, so GDPR is a little bit more, it's not, essentially it requires a legal basis for any collection process in the first company. So it starts from the principle of don't collect. Like, you can't do it unless you've thought it through and said, does a legal basis apply? One of those legal bases is consent. But there's a lot of other ways that you can legally collect and process information under GDPR, including what's called legitimate interest. If a company thinks that it has a legitimate interest in processing that data, just because of the type of business that it does or whatnot, that is a separate and equal basis for processing that information. In the US, I think we're just very unlikely to see a proposed regime that would start from that same basis of saying, don't collect, like no collection unless there's a legal basis. The ADPPA sort of actually comes close to kind of doing something like that, where it says at the beginning, here's prohibited, here's things you can't do. It's flipping on, or, well, no, it says, here's permissible purposes, right? So it is saying, like, yeah, you can, but it doesn't really go to all the way of saying everything else is impermissible. But it says, here's a list of permissible purposes for which you can collect information. So I think, yeah, we've learned a lot. The pop-ups also are coming from something called the e-privacy directive in the EU, which actually predates the GDPR. But they've learned a lot about that maybe consent and constant notification is not the best way to actually empower consumers and users. And that's maybe the other piece. There's two other things in the legal regimes that I'll highlight quickly, but I think they're just in some ways incompatible legal regimes. However, I think there are a lot of overlaps. There's a lot of convergence that happens between how we're thinking about privacy generally. The two things are that it's that this consumer versus like data subject distinction in the EU, because it's coming from fundamental rights perspective, there's more of a focus on data subjects regardless of their relation to the company. So employees are covered, government regulators collecting information are covered just as much as organizations and nonprofits. All of that, it's kind of all one group of people because it just thinks of people as people. In the US, because of the Commerce Clause, because of how we are used to regulating, it's more focused on consumers. However, in the ADPPA, there's civil rights provisions that are put in that would try to incorporate civil rights protections that are more broad and more sort of like a fundamental rights approach. The final thing, quickly, the EU is protectionist in its application of GDPR. The scope goes beyond its borders. The U.S. has never and will never probably propose a regulation that restricts data transfers outside of our borders. And that has led to most of the conflict between the EU and the U.S.
So I think all of you kind of agreed that, neither ADPA or COPA 2.0 has a chance for any of the whatever spending bill we get in December with the short deadline and stuff. But I think my question is kind of about kind of like an impetus and kind of like a deadline. I feel like Congress is more likely to move on things when there is any kind of deadline, even if it's self-imposed, and even then they might not. Or if there's some sort of like external factor, we have a hurricane and we need to give like money to do aid or something like that. So is there something that could drive, I guess, for either of these two bills, or, it would have to be reintroduced next year anyway, a companion or something that's similar that could kind of push this along, whether it's a deadline or something like external that could kind of move it forward?
I think we thought California's law going into implementation initially was the first deadline, and then they have CPRA, I guess, their updated version next January 2023, and that goes into effect mid next year. That could be another deadline. Doesn't seem to be likely because we'll have a split Congress, and we had both party control now, and they still couldn't get it. I'm not optimistic, but you're right. I mean, yeah. That Congress operates under deadlines. We had the Frances Haugen testimony. I think a lot of people are like, oh, this will motivate Congress. Maybe another big, whistleblower coming forth will. But we've seen it with Twitter and no legislation there. So I'm not sure. I mean, I think states will keep passing laws in the interim.
I think what I hear from some people on that point is just the idea that as states continue passing bills, it's going to take a certain type of law that really does represent a different color of quilt in the patchwork that would motivate people to really put the pressure for federal action. I think that would be, and so one of those types of things would be stronger private rights benefit in the state bill. I think that would be a signal that would create a deadline. But otherwise, it's an ongoing conversation, and I think it's amazing to see how far we got. And I think that there's still work to do to kind of have a better bill that I think everyone on all sides has issues with the bill, which is maybe shows that it is a compromise, which it is, but also there's improvements that could be done. So it's also good not to rush a good thing, but it has been 20 years that we've been trying to do this, so it's hard to say.
I think it's important to get it right, but I think a combination of been mentioned that we have various state laws that are about to go into effect in 2023 could be that impetus. And it's tough, once you have states that are passing their own laws for Congress to step in and preempt. And I'm not a subject matter expert on this issue, but I think back in 2015, 2016, there was a push for state laws on GMO labeling. In Congress, I believe it was a Republican Congress, Democratic administration agreed on the Safe and Accurate Food Labeling Act. I believe it dealt with Vermont's state law. So there's precedent for states passing their own laws that implicate interstate commerce, and Congress, a divided government, the administration and Congress working together to provide some clarity. And so maybe that can provide a roadmap for the privacy debate.
So I have a comment for Gavin and Ebbie, and then a question that for anyone. And it's I'm really interested that both of you talked about these opting into advertising on websites as like something that companies actually want us to do, because those opt-in and that GDPR, which has and the ePrivacy Act, which has forced these opt-in notices to appear, that those are maybe problematic because it's hard for consumers to opt into everything. And I feel like what you didn't talk about at all is that most companies design these opt-in forms to be really confusing. Like it's whether you want to call it dark patterns or manipulative design, like I always click opt out. I'm a privacy reporter, but sometimes I have to click around to find like where you can actually opt out. So I guess I just want to push back on that a little bit for the other reporters in this room as well. To like, it's not just about the GDPR making this more complicated for companies and like companies wanting to comply. Companies make it hard for us to comply, and so my follow-up, I'd love to hear both of your thoughts on that. And then my follow-up question is just, I know there was discussion about regulating dark patterns, and I'm curious where that is right now.
I will say that I think, and one of the things that's come out of the debate about ADPPA is we support clear standards to provide consumers with information they need to make that decision, and there being a uniform standard. And if that's and ultimately with the goal of protecting consumers. I think the point I was alluding to is there's a way to do it that leads to consent fatigue that doesn't actually empower consumers, doesn't achieve the desired effect of policymakers, versus one that, and every consumer is different. Like speaking for myself versus my family or colleagues here, there's a way to go about doing it. I think that achieves the purpose where it accurately communicates to a consumer what data is being collected, and that meets consumer expectations. But in terms of the actual practice of that, I can't really speak to how it could be worded. But I do think it's possible to further improve on the framework that we have.
Yeah, no. I would agree with you. Second that comment. I don't know that our choice is to make it hard or not. We actually spend a lot of time making sure that people can easily just say no. But one of the things that for Meta in particular, like we are in a data personalization, and we believe that our products are most effective when they apply directly to them. Right? So like that is a rub, and that I understand. But I also think that it's more when you are clear and transparent about what you're doing with folks' data. I think that gives them the opportunity. Sometimes it takes longer to get through that process, and so one of the things that we focus on is making sure that the experience, the entry experience, is clear, but it's also not onerous on the user as well, right? And we do appreciate the fact that like it can feel like we're just like bombarding people with consent notices, right? And my real point is that from our perspective, it's not as clear cut and dry in how we achieve that desired experience, right? So, I mean, I think that was the only point that I was trying to make, is that it really isn't as simple as saying, give them the option choice. It's like, what does that look like? What does actual choice look like? And that varies by product experience, individual. Actually, on the way here, before I got here, I had a conversation with one of my colleagues, and he was like, "Yeah, I don't really care, but my wife is like gung ho on it. She will not accept a friend on Facebook because of the connections that it may create, right?" And so like people are just very different on where they are in this space. And so we spend a lot of time trying to find that thread, that needle. And it's just not as straightforward as we wish it was.
Yeah, and I guess we're out of time, but just quickly, I think basically everywhere is where dark patterns issues are coming up. I think it's definitely a hot topic. It's well suited to the FTC's existing authority because it's deceptive, right? It fits within a deception idea. So some of the recent cases have touched on manipulative design patterns that would fall into this dark patterns category. But the FTC's rulemaking talks about it. ADPPA would cover in a number of different sections. The California ADPPA Design Code talks about it. And we see this trend towards recognizing that like when people are when we think it's appropriate for consumers to have that control and make those choices, it needs to be meaningful and informed. And some of these verbs or adjectives that are used in GDPR, those are kind of coming throughout a lot of the proposals. But yes, that's an ongoing theme. And the California and Colorado regulatory, as they're figuring out their rules, there's shortcomings there as well. Anyway.
Thank you all for your questions, and thank you all for your time.